Ashley Richards.
Caitlin Kirby on behalf of the people.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Richards, Your Honor.
Ashley Richards.
Ms. Richards hasn't been testing. What are we going to do on this? She hasn't been testing, and there's a current bench warrant out for her with no bond.
That's correct, Judge. I do have, I had a discussion with Ms. Richards. She had expressed some dissatisfaction with my office in general and me specifically. I don't know if she's wishing to ask the court for a new attorney. I do have some information that I can immediately refer to the court, but I didn't want to do that if that's the case, since I wouldn't want to step on a new attorney's toes in terms of what they wanted to do.
And Your Honor, no, regardless of what Ms. Richards' problems are with the public defender, she has failed to report. She's missed several tests starting from February to April 11th, and then was positive on April 17th and April 24th, and she has an active warrant.
As I said, Judge, I have a test as recently as May 2nd that I can provide to the court immediately, along with some other documentation. Again, I just didn't, given the nature of our last conversation, I didn't know quite how to proceed.
Ms. Richards?
Yes.
You haven't been going to testing according to what I have. I've issued a bench warrant out.
All right, guys, welcome to today's video. What starts as a routine court call instantly turns serious. Ashley Richards is brought up, and the court confirms she has repeatedly failed to appear for drug testing. The prosecutor lays it out clearly: missed tests, positive results, and now an active bench warrant with no bond. The judge doesn't hesitate, making it clear this is no misunderstanding. From the very first minute, the stakes are high, and the consequences are already closing in.
For no bond, you need to turn yourself into the Washington County Jail. I'm not even addressing the attorney issue at this point.
Your Honor,
you have counsel.
Your Honor, as I said, I have a test from as recently as May 2nd from her primary care physician. She is currently in a high-risk pregnancy. I'd ask the court to take that into consideration here. I would have turned those things in, but for the conversation, and I can do that immediately if the court would wish to give us another date. But given the nature of our conversation, I was kind of between a rock and a hard place.
And if Ms. Richards is a high-risk pregnancy, then why is she testing positive for drugs?
Well, I think that would be between her and her physician.
Today is the 6th.
I'm sorry, Judge.
Go ahead.
Oh, I was just going to say, this matter has been kind of rendered a little more difficult because she is in Muskegon, and we're here. We did find a testing facility there. There was no sign. It was actually in a law office. We do have some tests directly from her doctor. The crux of this is that there was an offer for use in this matter. This matter was actually charged after it occurred before, but it was charged after she successfully completed probation in Muskegon. I have documentation from Catholic Social Services there that indicates that she has been, that she did her primary care and then has been continuing with aftercare. Studiously. So there's that as well. I don't think it's a matter of her trying to flaunt anything, but just, there's a distance, there's financial issues, there's medical issues, and there's, but
on January, go ahead. But I'm just going to tell you, on January 26th, I approved that the defendant could test in Muskegon with results to community corrections. I don't have any results. I've been going back and forth, Mr. Gaddy, all along, and I don't know what her deal with your office. You're the only one that's been keeping her out of jail at this point.
As the hearing continues, the defense attempts to explain the situation. Testing locations, distance, financial struggles, and medical complications are all raised as reasons for noncompliance. On paper, it sounds complicated, but from the court's perspective, the issue is simple. The judge reminds everyone that permission was granted months earlier to test elsewhere, yet no verified results were ever submitted. What sounds like explanation begins to feel like excuse, and the court's patience is visibly thinning.
We further ordered that she could test in Muskegon. She needed to get the number to us. I signed a specific order that PD's office had done that regarding the modification of the location of her testing. We did that that was in late January. We then come through February still, and I don't have any tests. And she has continued not to test. And then I get a report on March 29th. This is some period in time. I still, at that point, don't have any tests. No test, no test, no test. Again, gave her a break, didn't do it. And then all of a sudden, I get to March 30th. Still don't have any tests. She's not here. And I issue a bench warrant. The bench warrant's been out since March 30th. Again, trying to get tests. Still don't have any tests. Nothing. We've just been continually putting it over. She decides she doesn't want to test. And then I all of a sudden get a test in April that indicates that she's then positive for THC. And then on the 24th of April, that the specimen has been diluted and there's been some adulteration of that specimen test. That was on the April 24th test.
Here, the judge takes full control of the courtroom and walks through the timeline step by step. January passes with no tests. February brings more missed requirements. By March, there's still nothing, forcing the court to issue a bench warrant. When results finally appear in April, they raise even more concern: a positive THC result and signs of specimen adulteration. One by one, each missed opportunity is laid out, leaving no room for argument or denial.
Yes, Your Honor.
We were here on April 27th, and I still don't have tests.
Yes, Your Honor. As I said, I do have a test from May 3rd from her physician. I can forward that. I believe I also have tests dating back as far as last year that I received this afternoon. I also have like I said, a letter from Catholic Social Services. If perhaps, if I'm still on the case, I'd be happy to submit those things. If the court would consider setting this over for Thursday week, which I think is the next preliminary or probable cause date, I can certainly send those documents.
Mr. Gaddy, I understand what you're indicating, and you've been trying to make sure to keep her out of jail, to do all of those things. Apparently, she doesn't appreciate that, doesn't appreciate what the court is saying, and wants to make her own rules. That's not how it works. So here's what's going to happen. Her bond is revoked. She needs to appear here. She needs to report to the Washington County Jail by 6 p.m. on the 17th of May. That is tomorrow. Otherwise, a bench warrant will issue.
Your Honor.
With no bond.
Your Honor. Can I say something?
You can say whatever you like.
I am due on June 5th, and they're taking me on May 28th to have my baby. And I have been testing. I have tested since I had that diluted screen.
I don't have any tests.
Your Honor, as I said, I can send those tests to the court. This is a unique situation. Had conversations. Well, anyways, as I said, I didn't want to air. I didn't want to do anything. If there was going to be new counsel, I didn't want to do anything that, it's kind of like do no harm.
Were submitted to the judge.
But I'm sorry.
I thought you submitted all those papers to the judge, you and Camille, because I've been working with Camille through your office too.
Okay. As I said, Judge, I can certainly put this together as a package and send it to the court However, like I said, there have been some issues that have come up, but if I'm going to stand that case, I would request the opportunity to do that. And before we take the drastic step of, well, there's already a bench warrant, but before we, I would just ask for an opportunity to do that and ask the court to extend us to.
I'm going to keep my ruling the same. Her bond's revoked. If you want to send something in, you can send it to Ms. Kirby. I will be more than happy to look at it and reconsider. But I'm not playing by her rules anymore. We're going to play by mine. I've been as lenient as I possibly can, and I'm not going to sit here and be taken advantage of. Defendant's ordered to report to the Washington County Jail, 6 p.m. tomorrow. She doesn't report, that bench warrant goes back out, plain and simple. If you want to submit something before in between time, if you guys patch up your differences and she lets you do that, that's fine. Then I'll look at it and see what I can do. But otherwise, that's my order. That's the order that will stand.
Did you say?
Thank you.
I'm sorry, Judge, just for my clarification. Did you say by close of business tomorrow?
She's got to report to the jail by 6 p.m. tomorrow.
All right.
That's what I'm ordering. If you want to submit something to me before then I'll be more than happy to take a look at it and hear from you and the prosecutor on it. But otherwise, that's my order.
Thank you.
In the final moments, the court reaches its breaking point. Despite last-minute pleas and promises to submit paperwork, the judge makes it clear that leniency has limits. The ruling stands firm. Report to jail by the deadline or face immediate consequences. The message is unmistakable. Court orders are not optional, and defiance will not be tolerated. Like the video, subscribe to the channel, and we'll see you in the next video.